Swayam Prabha. Digital India. Educated India.
Friends, what we do is to move on and understand the different aspects of public administration vis-a-vis the constitution. And the topic for discussion is fundamental rights. As you understand, friends, the question on rights is always related to a concept called the correlative duty. Wherever there is a right, we say there ought to be a remedy. However, wherever there is a right, there is always a duty to protect that kind of a right. Now, interestingly, friends, governance or good governance is all about being responsive to the rights and to do the best to protect the same. Now, interestingly, when you talk about the efficiency of a right in a country, good or bad, it may be average or on the top of it. This is actually a very powerful way to evaluate the working of a constitution, or what we call as the rule of constitutionalism. Constitution is the document, it is what is written. However, constitutionalism is the experience of the document by the citizens or by the society, or the history of the constitution about how it has worked over a period of, say, a decade, probably half a decade, or maybe half a century, or probably for 1 century and more than that. The Indian Constitution is more than 70 years old. The American Constitution has more than 3 centuries of history. However, you will notice that the idea of good governance is a very, very powerful and emerging idea in terms of making administration far more responsible, making administration far more citizen friendly, and probably caring for the rights of the citizen. Now, a lot of international agencies insist on good governance or the principles of good governance, and it has been laid down from time to time, including by the United Nations, institutions like the World Bank, UNDP, OECD, and Asian Development Bank. And they have successively insisted on the different parameters. And please note, the principles of good governance have always evolved. As we speak in the era of liberalization, globalization, privatization, good governance could mean entirely something different. And pre-LPG era, it could have meant quite different. However, I think the international agencies look at developing the normative framework of administration in different countries. And they expect the states to perform the functions in a manner that promotes the value of efficiency, the value of being not corrupt, and the value of encouraging civil society movements. And hence, you will notice that in a country's growth, while we have parameters like social growth, of course, political mapping is also very important in terms of free and fair elections, gender rights, representation of women in parliament, and so on and so forth. It also matters in terms of the economic parameters of governance, which is the country's GDP, the levels of poverty, income levels, happiness index, so on and so forth. So I think good governance is about what we may also bring about as what we say as sustainable human development. Of course, developing the human potential or the potential of a population and its citizen is one of those essential administrations in good governance. And what does this, the parameters of governance extend to government agencies, it extends to business houses, it extends to public policy and public affairs. And of course, do not forget that good governance is also an important parameter in terms of administration of justice. So you're not talking of governance vis-a-vis only the legislature and the executive, but also the strength of the judiciary, or the kind of autonomy, independence of the judiciary also matters in the evaluation of good governance. What else is good governance? Good governance, friends, is the fact of what we call as a government that also has limit on its power. The limitation or the control of public administration, how far and to what extent there are checks and balances, or what we call as the parameters of control of abuse of public administration, also would define good administration. Uh, uh, you know, we always say that the effectiveness of any system is something like this. It is one, good management, good administration, and good governance. And though the very fact that you talk about, say, things like participation, rule of law, transparency, responsiveness, consensus orientation, equity, effectiveness and efficiency, and finally accountability. All these are certain elements that would probably look at the key attributes to identify and judge good governance. However, all of these, really get tested when it comes to protection of human rights, when it comes to protection of fundamental rights in any society, in any democracy, or in any country. And hence, when it comes to rights that are enshrined in the Constitution, that are protected under the Constitution, the effectiveness of governance is then brought into the forefront. I think when you talk about, say, institutions even like the Lokayukta, I think we will discuss about Lokayukta, the Ombudsman, little later. But you will notice that one of the essential elements of bringing the Ombudsman rule, or the rule of a watchdog over governance and government, is probably to bring in some kind of an agency that can actually control the state and its bureaucracy, or to try and balance public administration, as the case may be. Of course, the role of the Lokayukta is to check corruption. The Lokayukta and the Lokpal's role is probably to bring in efficient administration, or more people-centric or people-oriented kind of an approach. So I believe that many of these institutions that we have established in the country have started to contribute towards good governance. And I think that is one effective mechanism of trying to bring in the law, as the case may be. Now, all of these elements of good governance only will contribute for protection of individual liberties. They will contribute to the notion of democratic values. They will also bring in an element of what we call as the following of the principles of natural justice, which I think are the cornerstones of any democratic society. And I think the Constitution of India lays down the principles of natural justice. You will notice that, of course, the principles of natural justice are, about the, natural justice, the term natural and justice, which means by the very fact that you are a human being, you are expected to be treated fairly, you are expected to be treated equally, you are expected to be treated in a non-arbitrary manner. And as a human being, because you have granted the right of the state, or to the state, to administer and govern you, the state cannot unfairly infringe upon your rights. So I think the state has to protect the ideas of liberty, equality, and fraternity. And interestingly, the test of good governance and the principles of natural justice that are expected to be put across are actually there in Article 14 of the Constitution of India. It is there in Article 19 of the Constitution of India, and it is there in Article 21. So whatever we have spoken so far in the last couple of minutes, I think is actually called the Golden Triangle Rule. Now, the Golden Triangle is an interesting triangle which has Article 14, it has Article 19, and it has Article 21, which is on the top, which is about right to life. So your right to life is at a pyramid in the triangle. It's on the top. It is the most essential right that ought to be protected. And any kind of infringement of right to life can only be done so as per procedure established by law. That's what is written in the Constitution of India. And Article 21 is the kind of heart and soul of the Constitution of India. And the bedrock or the foundation on which right to life is based on is what is there in Article 14, which talks about equality before law and equal protection of the law. Now, these are two very heavy emphasizing foundations of the Constitution: equality before the law and equal protection of the law. The word protection over that assumes a great amount of significance. We'll probably discuss that in greater detail with case laws and illustrations as the case may be. Now, Article 19 is about those very essential freedoms that are to be enjoyed as a natural human person. The freedoms in Article 19 include the speech and expression freedom, the movement freedom, and the assembly and association freedoms. So all of these, friends, now if you see the pyramid structure that is there in the slide, very clearly take you into this golden triangle rule. The golden triangle is a kind of an essential creation of jurists who believe that if public administration and good governance ought to be made a rule, and it has to be made a practice in every form of public life, in the bureaucracy and in the government, then there ought to be absolute respect to this golden triangle rule. And any violation of this constitutional protection must result in adequate remedies. And you will notice that those remedies does exist under Article 32 of the Constitution as well. Of course, you will notice that very often than not, good governance vis-a-vis a lack of application of the principle of natural justice will result in infringement of various rights. It will result in arbitrary exercise of power. And to check the executive, to check public administration, I think it is the role of the judiciary through the protection of or issuance of writs under Article 32. It could be the writ of mandamus, it could be the writ of certiorari, prohibition, quo warranto, and the writ of habeas corpus. I think these are the essential orders of the court that try and limit the authorities, they limit the power, they check the abuse and misuse of the same power. So I think very important is that good governance means an absolute abidance of the principles of natural justice. Remember, the principles of natural justice is a rule. It, of course, has certain exceptions where it cannot be absolutely followed. However, I think it is the kind of stick that is to be used in public life, in public administration, so that the constitutional rights or fundamental rights that are granted to the citizen are protected from time to time. I think one can notice the Shankar Shukla case, which the Shankar Shukla, Neelbatti Bera, and D.K. Basu cases. And the judiciary has, on time to time, clearly laid down the emphasis of good governance from time to time. For example, in the D.K. Basu case, I think what the court did was very, very important, because the court laid down the dimensions of the criminal justice system, literally. Because unfortunately, if you look at it, custodial death in India were quite frequent, and to a larger extent, it showed the abuse and misuse of police power. And custodial death today is considered as a blatant and naked violation of human rights. And it is the duty of the police, whatever may be the issue, whatever may be the case, it may be a medical emergency, it could be any other issue. I think once a person is in the custody of the police, ensuring his care and protection and to ensure that his rights are not infringed in any other form, despite the fact that he may be an accused, he may be a convict, he may be been guilty of a particular offense, I think to a larger extent you will notice that limiting the police power, the D.K. Basu case has laid down guidelines, and these guidelines are interestingly under the Constitution of India, because they're coming from the apex court, because they're coming from the Supreme Court of India, they are considered the law of the land. So the duty of care by the police. Now, please note, the duty of care by the police is not only towards free citizens. The duty of care of the police is also towards the accused, towards the prisoners, towards those who are convicts. They might have, been the so-called bad person in law. They might be the persons who may have, violated a given law. But that does not take away the fact that the Constitution also recognizes the rights of an accused. So, accused also have fundamental rights, and custodial torture, custodial death. I think custodial torture is unfortunately a very, very, kind of a British colonial legacy that continues to be in the police system, with methods of torture being like first degree, second degree, and third degree. And this is usually resorted to by the police to probably extract information, extract some kind of a truth. Sometimes they look at confession so that they can collect the evidence, so on and so forth. Um of course, yeah, that's what the Supreme Court does from time to time. What the Supreme Court has done from time to time has probably kind of ring the power structure in this country. And to make them responsive and responsible, I think the judiciary has played a very important part and important contribution. Now, let us move on and look into the first article for our discussion under fundamental rights, and that is Article 12. Now, before we go to Article 12 and understand the aspects of Article 12, continuing from where we left in terms of good governance, the principles of natural justice, and how the constitutionalism has evolved in India, I think one will notice that India still has a very high rural population. Now, the rural population has been dependent upon agriculture. Agriculture, unfortunately, right now looks to be quite, decently profitable, but has not been for a long period of time. So, people in the rural areas are considered, far more not so very affluent in terms of money or money's power, and of course, they are not supposed to be also that literate, though things are changing and evolving in India. And hence, once the literacy rate is down in the country, you will notice that there is going to be abuse of power by the government. So, good governance becomes very critical and important when it comes to the vulnerable sections of the community who cannot read and write. And I think that is the real emphasis of good governance. So, you test good governance from those who probably do not know the law, do not have access to the justice system. And that is precisely when good governance becomes the most critical part in society. However, I must state at this point of time that because of technology, because of mobile cameras and so on and so forth, I think to a larger extent that accountability that is required has slowly started to come in. And I think those are some very important mechanisms of how we are dealing with the constitution. Now let's come to the concept of state. Friends, Article 12 of the Constitution defines the term state. And you will notice that this is very, very important in understanding Part 3 of the Constitution. The reason why it is important is for the simple reason is that fundamental rights are supposed to be governed by the state. They are supposed to be protected by the state. As I told you, citizen versus state. It's not necessarily versus, but it is the concept is the duty of the state is always towards the citizen, and this is where the whole relationship of the state and the citizen arises. So, Article 12 kind of establishes that kind of a relationship. It lays the foundation of that relationship. So, when citizens are to be exercising their fundamental rights, when citizens are supposed to be, enjoying those kinds of freedoms or rights that are enshrined in the Constitution, then it becomes the obligation of the state to protect it. So, who is the state? Right? That becomes a very interesting and most important factor. Now, of course, if you read Article 12, you will see that the state is no doubt the government, but it's not just the government in terms of the legislature, executive. It can be, certain local bodies or local authorities. Now, interestingly, on the concept of why state is important or why should we understand the state in the context of the Constitution, Part 3, it is because it is the state that can actually make law through the legislative body. And please note, the legislature in India is at the central government, it is at the state government, it can be at the local government as well. So we have three tiers of this government, and they can actually make a law. Now, interestingly, infringement of fundamental rights is not only through executive action, it can also happen through enactment of a law. which the executive then has to follow. So it starts from the parameters of a law that is tested on the basis of whether it is constitutional or whether it's unconstitutional. How is it unconstitutional? When any such law that is made by the state infringes directly or indirectly on their fundamental rights, such a law can be struck down as being unconstitutional. Hence, once it is unconstitutional, the executive cannot have the duty or obligation to implement it. Interestingly, when you look at what is law, please note, friends, the state can make different kinds and varieties of law. So, if you refer to Article 13 of the Constitution, law includes, it definitely is an act. It can be rules, regulations, it can be orders from time to time that is issued, it can be regulations, it can be bylaws, so on and so forth. So all of these form some kind of a law. So, law is not just an act, it's not just a rule. All other forms that you have seen over here in the slide are also considered law for the purpose of the Constitution and for the purpose of the legal system. Which means, please understand that while the Parliament or the State Assembly makes acts, the rules, regulations, notifications, orders, bylaws, and regulations are generally made by who? They are made by the executive. They are made by the public administration. So, public administration in India also contributes to lawmaking. These are what we call as delegated legislations. So, legislation is an act. Now, the legislations allows for the executive to make rules, and this is how the delegation happens. Of course, the rules will then further delegate in terms of regulations or orders, and hence that is the basis of how delegated legislations are brought about. Now, in India, we do not follow the strict separation of power theory. I've already dealt about this, which means you don't expect the legislature only to make law. You don't expect the executive always to implement the law. The executive also has a role in law making. And where do they have a role in lawmaking? They have a role in lawmaking through what we call as delegated legislation. However, one would notice that in India or in most jurisdictions, you will notice that it is delegated legislation that becomes the major chunk of rulemaking. Yeah, because acts are very few, and how the act has to be implemented. We say an act is substantive law; it just defines what is there. But later on, the procedurality of putting that act into force is in the form of delegated legislation. So that is where a large amount of law is created, a large amount of public administration comes into force. So please note, when the state is going to be defined, it is not only the legislature that makes acts, but the executive that also makes these rules or regulations. That also has to be included in terms of testing whether that rule, that regulation, that bylaw is constitutional or not. So the courts will test it. Because interestingly, friends, the act may look very fine, but suppose there is a local public officer or a public servant who then passes an order in which there is an infringement of rights. Can that order actually infringe my rights? No, they should not be allowed to be done so, and hence the challenge can definitely be brought about. So the state includes all of these agencies which can be tested under Part 3 of the Constitution, which is about protection of fundamental rights. Of course, please note, thanks to the 1992 amendment to the Constitution, which brought in the 73rd and 74th Amendment, today we have something called even local authorities. These are kind of constitutional bodies. They are not necessarily attached to the state or the central government. They are constitutional bodies because they're supposed to be autonomous and independent, supposed to be, at least constitutionally they are. And these are agencies like the municipality. This can be the panchayats or other trusts and boards. And these are local authorities in the sense that a municipality or a panchayat can also make certain kind of regulations. And whenever they make it, they are making it as a state under Article 12. And hence, all of these agencies that you see are supposed to be the agencies that have the duty. So the Constitution imposes on the state a duty to protect fundamental rights, a duty to look at citizen-centric approach, a duty for good governance, a duty to follow the principles of natural justice. These are the duties of the state, and these duties then are towards the citizen. That is how the dimension of the Constitution has been brought about.